For viewers across Africa and the rest of the world, this is NC Continental Prime. I am Gbenga Aborowa. We begin in South Africa, where the Electoral Amendment Act is once again facing another constitutional court challenge. This time around over the signatures required for potential independent candidates to be qualified and how seats will be recalculated when the vacancies occur. In April, President Cyril Ramaphosa has signed the bill into law allowing independent candidates to run in provincial and national elections in 2024. However, organizations are challenging the fact that only 200 of the National Assembly seats are available to independent candidates, and this will create an unfair election and reduce the value of votes cast in favor of independent candidates. Now, joining us live to discuss this further is a political analyst, Asanda Ngoasheng. Good evening, Asanda, and a warm welcome to you.
Good evening, and thank you for having me.
Now, Asanda, what are your organization's motives for challenging the Constitutional Court order and valid?
Well, we have a situation in South Africa where people have been complaining about the electoral, laws and how they discredit and give more credit to different kinds of organizations. And so I'm not surprised that, these independent organizations have gone to court. First, it was around the fact that half of the seats in South Africa's legislative arm, which is Parliament, are going to be available to independent candidates, the other half essentially going to political parties. And then now they've made this rule, which essentially requires independent candidates to have up to, a minimum of 10,000 signatures, which represents about 15% of the required vote for each province. So the issue is not necessarily that they require 15,000, but the issue is that previously political parties only needed 1,000 signatures. And so now that independent candidates are going to be brought into the system, suddenly the requirement has gone 100 plus fold. And that is what people are complaining about. And it does speak to, the unfairness of the electoral system and the unfairness of the thinking based on the fact that the incumbent, which is, the current system favors political parties, when South Africa has been very clear in saying that they feel that the political party system is not working for them. They feel that the people who purport to represent them in the legislative arm of government, which is Parliament, are not doing their job. And this is why South Africans pushed for electoral amendments. And now that the amendments are here, the incumbents, both in terms of the governing party and the opposition parties, because they are, of course, the ones who are in Parliament making laws for us until we get the independent candidates, are now pushing to ensure that the political party system continues to thrive and continues to be, the winner, because it's easier to get 15,000, 10,000 votes when you are operating as a political party with multiple people than it is to do so as an individual. And it is unfair that, when it was political party system, you only needed 1,000 votes. And now suddenly the numbers have been increased so exponentially that one candidate is going to require a minimum of 10,000 people from 1,000 people for them to even be considered to be a viable candidate.
Now, Asanda, having said this, do you believe the act benefits bigger parties and, like you said, creates an unfair elections as alleged by certain groups?
Because the act, definitely benefits bigger parties and definitely benefits political parties in general, because they are the incumbents and they do not want a system that's going to allow for independent candidates to be able to compete with them effectively, because South Africans have already complained. That's how we got to the electoral amendment in the first place, that South Africans were saying the current political party system is not working because you would have, a mayor or even a premier or any other leader who belonged to a political party who was, ahead in terms of political party list, but was not one of the favorite of the people and no longer represented the people people on the ground, and people wanted a more direct system that would allow them to be able to punish and reward whoever it was that was in leadership. And that's why this system of independent candidates was brought in, because as an independent candidate, the people who have brought you in have the right to then kind of implement certain structures within the political system that make you no longer able to access that seat that they have given you. And so we have seen in South Africa over the past 30 years, political parties that have forgotten that, it's all about the people shall govern rather than the political party shall govern. And we've seen, for instance, in the African National Congress, who's the governing party, many complaints about situations where people were at the top of the ANC list in terms of the province or in terms of, the various areas for municipal governance. But these people were not necessarily the people that the people on the ground, aka the residents and the citizens of South Africa, wanted to be the ones who lead them, wanted to be the ones who represent them. And so South Africans forced this kind of change in because they wanted to have a more electorally responsive law that people will be able to say, we voted you in, we can vote you out. In the political system, it's much more difficult to do that because your political party peers have to agree that you deserve to be removed. But I must say what's been interesting is that this particular week, we've had one of the most senior former senior people in the ANC removed, which shows that, on some level, political parties are understanding that, people can and will lobby for people they no longer want to be part of political parties or representing them to be removed. But it's not as easy as it will be when you have independent candidates who would be in some ways directly elected by people rather than having to be popular on the political list, regardless
now, quickly,
of how popular.
Asanda, sorry to cut in. Just before I let you go, I do understand that this case is in court. Now, how likely is it that these pending court challenges against the Electoral Act will be finalized by 2024 when the elections take place? When are we likely to get a verdict?
Well, the Constitutional Court doesn't really have a choice but to ensure that these kind of nicks in the system are sorted out by the time we get to 2024, when South Africa is going to go to its next election, because it has implications for our democracy and the ways in which our democracy is seen to work and the ways in which our democracy does work and does represent people. And this is, quite groundbreaking in the sense that we're beginning to see the formations of a hybrid system between independent candidacy and political party system in South Africa. And this is something that hasn't happened before. And it's going to challenge particularly the political party system, which has been firmly entrenched and has unfortunately allowed people who should not be in government to be in government, and those who should no longer be in government to continue to be allowed to be in government, despite what human beings on the ground that they're supposed to represent believe and think about them.
Thank you very much, Asanda, for your time and your insights. We do appreciate your contribution. Thank you.
Thank you very much for having me.
Asanda Ngoasheng joined us from South Africa.